Welcome, everyone. Thanks for making the trek out tonight. We're very grateful that you're here and participating. As you know, it's going to get a little stuffy here. We aren't immune to the powers of Mother Nature and the electrical outages, and I know our teams here have been working very hard to make sure that we have our generators up and running. Even for today, I'd like to give a special shout out to Corey Reisner, our city electrician, and of course our IT department. They've been working really hard despite the power outages to make sure that we could have a meeting today. So we're a little bit limited on technology, but that shouldn't interfere too much in our ability to have some fruitful dialogue. So we appreciate your patience, and thanks for making it up. If it gets too hot, you know, if the air isn't good, we can probably just raise your hand, let us know, and definitely we'll look at opening up a window if we need to or something. So I'm going to call to order the 6 p.m. special meeting work session to order. Unlike our other meetings, we're going to have public comment at the end. With these work sessions, we really want to hear and discuss all the things and then hear from the public afterward versus up front. So this is a work session. We won't be making any decisions tonight, but we will be learning more about this very important topic. And with that, I think Mr. Gillum, it says review of current legislation as our first item.
Thank you, Mayor. Good evening, everyone. Mayor, as you've indicated, we're not under the best of conditions tonight. We had hoped to be able to display for you, among other things, an interactive zoning map, which would deal a little bit with some of the different marijuana uses and setbacks and things like that, because of the fact that we don't have computers up here in the council chambers. We're not going to be able to do that tonight. But to be honest, we didn't expect that we'd be able to go through everything with any kind of finality tonight anyway. So we can save that part of the discussion for a different day, because we're expecting that we're going to have to continue this discussion on a different night at a different time anyway. So, with that in mind, this is a work session. We do have something of an agenda, but it is a free-flowing agenda at that. There's a lot of ground to cover here. Three different related pieces of legislation that I'm going to be talking about. In addition, some emergency rules, which stem from the legislation. Legislation that is complex, that is not necessarily consistent in terms of the terms and the provisions. So let's just work through this together tonight. If you have questions as we go through the materials, in terms of what I'm going to be presenting, if you have questions, please let me know. Just to let you know on the front end, I may not have definite answers for you tonight, just because of the fact that the subject matter is complex, and because we're talking about inconsistent language or similar language with different meaning in different acts. There may come times tonight where we're actually punt. I'm going to take your question, and I'm going to take some time and look at the question and make sure that the answer that I give you is going to be the right answer, and not just one off the cuff that may not be entirely right. But again, we'll do the best we can tonight. So I thought it would be appropriate for us to get started to kind of talk about where we've been before, that is what's going on before, and how it is that we get to be where we are today. I think any discussion about marijuana in the industry needs to start with the Michigan Medical Marijuana Act, which, believe it or not, was more than 10 years ago. That was 2008. The initiative legislation first passed that provided for the whole system of qualifying patients and caregivers that's still in place today. So really there is nothing in any of the subsequent legislation that directly affected the framework that was set up by the original MMMA. The 2016 legislation, the Facilities Licensing Act, my personal opinion was maybe kind of an offshoot of some of the deficiencies or the questions that weren't answered by the original act. But the important comment is that the original framework is still in place in terms of patients and caregivers. That's still all in effect today. So, the next bullet point on the timeline is 2016, when the state legislature actually passed legislation having to deal with the subject. That was the Medical Marijuana Facilities Licensing Act. And as the title of the act indicates, we're talking about facilities. And the reason I emphasize that is because in comparison with the most recent legislation, which talks about establishments, the first legislation talked about facilities. So when we're talking about medical marijuana businesses, we're talking about facilities. When we're talking about recreational or adult use marijuana businesses, we're talking about establishments. Just kind of keep that in mind as we move through. And the MMFLA, the 2016 Act, provided for 5 different kinds of licenses. Growers, which is kind of self-explanatory, individuals or entities that would grow marijuana and then sell those to a couple of the other licensing classifications, to processors or provisioning centers. Processors are licensees who take marijuana and then either extract or somehow or other create a marijuana-infused product, which they in turn sell to a provisioning center. And a provisioning center is, for lack of a better word, I guess really a retailer. To kind of jump ahead to the last legislation, that's what the commercial establishments are called in the last act. Retailers' provisioning center is to sell marijuana products to patients and to caregivers. That act also created a license called a secure transporter. Basically, their obligation is to store and transport marijuana between other facilities. And then also a safety compliance facility, which would test the quality and for any contaminants in marijuana and then return the marijuana after it had been attested to a different kind of a facility or to a caregiver. So those were the 5 types of licenses set up under the MMFLA. The MMFLA is an opt-in piece of legislation. That is, unless the city says that it wants to allow medical marijuana facilities are not allowed within the city limits. So we have to take affirmative action to allow those to opt in to the program. As of this point in time, the commission has not taken any action to opt in to medical marijuana. If the commission were to decide to opt in to medical marijuana, you can allow all 5 of the class of licenses. You can allow some of the 5 classes of licenses, or if you chose not to opt in, you wouldn't have to allow any of the licenses at all. So you can pick and choose as to what kind of licenses you want to allow, and then above and beyond that, you can also pick and choose through use of the zoning ordinance and other legislation to choose where in town you want those establishments to go. So facilities, yeah. Again, it's hard to keep the terms straight, so you should be throwing a quarter in a cup, right? So, the city does have other general authority to regulate facilities. However, we cannot, under the Act specifically, impose any kind of regulations on the purity of the marijuana or the pricing of the marijuana. Also, just generally, it wouldn't come as a surprise, but we're not allowed to have any other kind of an ordinance that conflicts in any way with the MMFLA. We're preempted in that sense from having anything that's contrary to the MMFLA. So, general questions for you to think about in terms of the MMFLA. Medical marijuana, if you will, just to make it easy. Should the city be opting in? Again, we have not opted in at this point in time. If the city is going to opt in, what kind of facilities should the city be allowing? And if the city is going to opt in, if the city is going to allow any or all of the 5 different kinds of facilities, where in town should we allow those facilities to be located? So I don't know if you want to stop and talk about medical marijuana specifically right now, or if you want me to go ahead and move into recreational adult use, because some of the questions are the same if you want to talk in a bigger sense. So I mean, I guess we'll leave that up to the commission at this point in time.
Does anyone have any questions for Mr. Gillum at this time, or do we want to? Okay, Commissioner LeVasseur.
With the decriminalization of marijuana, I'm wondering what the future holds for medical marijuana. If there's some aspect to the medical marijuana statute that will still be relevant once the recreational or adult use is fully implemented statewide.
I mean, that's a good question, and I think there are some minor distinctions between the two. Again, I'd have to take a look at it, but I think there may be some minor difference in terms of like home delivery and things like that. But I think you raise a good question. I think to a large extent, again, my opinion, the recreational or adult use marijuana legislation has in large part subsumed a lot of the terms or privileges that were given under the Facilities Licensing Act.
One of the acts allows for home delivery and the other one does not?
Off the top of my head, that's my recollection, but I want to confirm it. So, yeah.
Commissioner Macy.
So I thought they both allowed for home delivery, but I could be wrong about that.
And you could be correct too. So.
And then I was just going to say, it seems to me that there might be some communities that would prefer to remain opted into medical marijuana but not opt into recreational adult use, which might mean that the two would continue side by side for that reason. Just my 2 cents on why that might happen.
Commissioner Perush.
I think I had heard somewhere, and I have no idea where, that when it comes time for the state to actually begin issuing recreational marijuana licenses, they will give first preference to those holders of medical marijuana licensors. In other words, they will move to the head of the pack. So that's my first question is, have you heard that? Is there any validity to that?
Yeah, I believe that is correct, yeah.
Okay.
Since they've already been through the state qualification process, I think that
It would make
the
sense
state is
from-
concerned with being able to actually have marijuana out there for public consumption when the act becomes fully effective.
Right, because they've already gone through the whole investigation administrative approval process already in that once. The second question I have, and it might be either for you or for Tim, have we had requests or any interest from any members of the public or businesses for medical marijuana facilities in the city? I certainly haven't heard anything, but I don't know if anyone on the staff has heard, or anyone else has heard. You know, it would be nice if we could put one here.
We've been getting requests for all kinds of facilities, whether it's the medical marijuana or the adult use. People are calling and asking for the process. Right now, because you haven't opted in or opted out, we're telling everyone you can't operate very well.
Okay, but there is interest out there for the medical as well as the recreational. There is interest for both medical as well as recreational.
Absolutely.
Okay, thanks.
I think Todd Fenton, our Economic Development Director, I think he would echo those statements too. I think he's taken a number of calls for both.
Okay, thanks.
Any other questions on the medical side? Okay.
Okay, then the next piece of law to talk about, if you will, was the next initiative petition, which was passed in 2018, which is the Michigan Regulation and Taxation of Marijuana Act, or the MRTMA, if you will. Again, this was as a result of initiative petition, and this is for recreational or adult use marijuana. It provides for sale, use, consumption, and cultivation of marijuana by individuals, and also for the licensing, regulation, and taxation of marijuana establishments. So again, not facilities, no, we're talking about establishments. So, and there are some significant differences between the two pieces of legislation, so that's why I think it's important to keep in mind facilities versus establishments as we continue our discussions. Again, the MRTMA set up a similar but not identical framework for licensing. The MMFLA had 5 licenses. The 2018 legislation has 6 different licenses. Again, a grower, and then like the MMFLA legislation, there are different classes of grower license based upon the number of marijuana plants that you have. But the different classes are different between the 2016 Act and the 2018 Act. So you got classes A, B, and C grower license, but the number of plants involved between the 2 different pieces of legislation, even though they say exactly the same thing, the number of actual plants that are involved is different. So there's a provision for a processor, like there was under the MMFLA. The secure transporter, the provisioning center under the MMFLA now becomes a retailer per se. Again, the function is basically the same, but we're talking about a retailer license. The safety compliance establishment, again, that's similar to the facility under the 2016 Act. The new license that was created by the MRTMA directly is the micro business. That is something new compared to the other act. The micro business is, I don't know, I've heard somebody compare it to a microbrewery in the LCC context. It basically is more of a one-stop shop. It allows for a single entity to act as a grower, processor, and retailer. So they can grow their own, they can process their own, and they can sell their own. Whereas under different circumstances, generally, you're going to have different entities that are working together. But the micro business, subject to certain limits in terms of number of plants and things like that, can be more of a one-stop shop, if you will. The MRTMA, unlike the MMFLA, is an opt-out piece of legislation. So in other words, if you don't want to participate in the adult use recreational marijuana area, you have to take affirmative action to opt out. At this point in time, the city has opted out. We did that in February of this year. But if you remember, the opt-out that we did had a sunset provision in it. So our opt-out is on the books now, but it ends in February of next year. So in roughly 6 months, unless something different is done with that ordinance, then we are, by virtue of the fact that we will no longer be opting out, we will be opting in. If you do opt in under the MRTMA, you cannot pick and choose the types of establishments that you want to allow in the city. So all of the 6 that I've listed for you, if you're in under the MRTMA, you're in all the way. You have all 6, generally speaking. You can, however, limit the number of each one of those establishments that you would allow in the city if you wanted to do that. The wrinkle in limiting the number of establishments, and I would submit to you, although we haven't really talked it all the way through or thought it all the way through on a staff, from a staff standpoint, is you could either do it by setting a specific number, which I think some communities have done. I think you could kind of back your way into it by looking at what your zoning ordinance would allow and things like that, and you could, based upon the zoning districts that you allow and some of the proximity requirements and things like that, then you could effectively impose a cap on the number of establishments that you would allow. But the legislation is really very clear. If whatever cap or limit that you impose on the number of any class of establishments in your city is, if the number of qualified applicants at the state level exceed the number of establishments that you're going to allow in the community, then it falls on you, on us, on Royal Oak in this case, to come up with a competitive process to determine which of those qualified applicants at the state level are actually going to be able to get licenses from the city of Royal Oak, to get authorization from the city of Royal Oak. And the standard that the Act sets forth is it has to be a competitive process to select the applicants that are, quote, best suited to operate in compliance with the Act in the city of Royal Oak. Exactly what that means is probably something that attorneys and judges will be having fun with probably for several years. Again, that's an area that we'll have to have more discussion about, but my general understanding is that just about every community that has imposed some kind of a point system or some kind of selective criteria to determine who is the best suited has ended up being sued by someone who was not found to be best suited to be eligible for a license in the community. So, but again, that's probably a discussion for a different day as we get more into the details of this. So, other than that, we do have general authority, subject to not doing anything that's inconsistent with the Act itself, to impose regulations on the time, place, and manner of establishments. The one interesting thing I thought in the Act was that the default in the Act is that no establishment is allowed under the Act within 1,000 feet of any kind of public or private school. But a local community, in our case, the commission does have the opportunity to shrink that proximity distance down. So you could allow an establishment to be located less than 1,000 feet from a public or private school if you wanted to. 750 feet, 500 feet, whatever the number might be. And again, it's too bad that we don't have full power up here tonight, because I know that James had done a lot of work on that in terms of working with data that he had gotten from Tim in the planning department about where schools and churches were located in the city now, and what 500 feet from each of those locations meant, what it looks like on a map, what 1,000 feet looks like, and so on, because it really does kind of carve out certain areas of the city. So again, that's another point that we're going to have discussion on a different day when we've got all that information available to us. So under the MRTMA, the questions that staff has for you at this point in time, at this point, as of February of next year, we are opting in. So should we continue to opt in? Should we stay the course, so to speak? And if we are, then where in the city should the 6 different types of establishments that are permitted under the Act, where should they be allowed to be located? If there's any questions or comments, discussion on the MRTMA?
Mr. Bruce.
You said that a community, if it decides to opt in, has to allow all 6 different kinds of businesses, establishments within the recreational category. But if we don't, say for instance, want growers, we want no growers in the city, could we effectively create a zoning ordinance or zoning map that would make them not available within the city, where we're not affirmatively saying, no, you can't come, it's just that there's no place where you can go? In effect, can we do spot zoning or no spot zoning with this kind of thing?
Or exclusionary zoning?
Exclusionary zoning?
Yeah. No, I don't think you could, no.
Okay.
No, I think we have to allow for at least some location somewhere in the city.
Okay.
Whether or not that, they could actually locate property that the establishment could either acquire or could rent to use, that's really not an issue for us, but I think we would have to allow for the use somewhere in the city.
Okay, so that when we're looking at the zoning map, we're going to have to decide not only perhaps where we want the retail establishments, but we're also going to have to figure out where we would permit all 6 of those categories. In other words, we're going to have to identify perhaps a location in the city where a grower could potentially locate.
Potentially, yeah.
Okay. Okay, that was my question. Thank you.
Commissioner Gibbs.
With the new regulations, are we able to combine, so have a grower and a processor under the same roof? Or a lab and a grower under the same, in the same building? Or a provisional center, or I'm sorry, a retail center and a lab in the same building? Or are they separate, always separate?
My understanding, and I'll confirm this, but my understanding is that the act does allow for some stacking of licenses.
Okay, and that's my understanding as well, but I wanted to
But they'd
throw
still
it
have
out
to
there.
get 2 licenses, right? So you'd have to have a grower's license and a testing license. And you could possibly be located in the same building, but it would be 2 approvals, 2 licenses, correct?
Correct, and you'd have to comply with all the different regulations
Right.
that apply to each of those classes of license.
Okay.
Yeah.
I'm going to go with Commissioner LeVasseur and then Commissioner Douglas.
So we have the ability to shrink the distance from a school or a church from $1,000 feet to something less. I presume the opposite is not true. We cannot increase that distance.
Correct.
And with regard to the micro businesses and the retailers, is on-site consumption automatically allowed in any of those instances, or is there something further that needs to be done, special permit or anything like that?
Again, my understanding is that the micro business would allow consumption on site, but I don't believe any of the other licenses would. There is a special class of license that was created under the administrative rules that I'll get to in a couple minutes. But that's something outside of the scope of the act per se.
Okay, so automatically, a micro business would have the ability to provide on-site consumption. There's no additional permit requirements, special permits or anything like that, special event permits or anything like that.
That's my understanding, yes.
Actually, I'm going to wait because I think my comment is, or my question is more appropriate to the item 4 on the agenda.
Commissioner Dubois.
Sorry, I want to make sure I'm understanding. So, as you said, there's no way to discriminate between the types of licenses. So if we were to say, you did say we can say how many licenses we're going to allow. We could say we're going to do 2, in theory. That is allowed.
We're going to do 2 grower license, 2 retailer license, something like that, yeah.
So if we do 2, it has to be 2 of each type?
No.
Oh, so we can
No.
say 2 retailers,
Yes,
and that's it?
but you have to allow for the other types of licenses too.
At least one.
So there has to be 1 allowed of each type if we opt in. That's what I'm trying to get.
We have to allow for it, yes, somewhere. I think the point that Commissioner Perush was raising was, could we effectively keep one type of license out by making it so difficult there wouldn't be literally anywhere in the city where they could go. I mean, if we said you can't be within 1,000 feet of a school, public or private, a church, a park, a residentially zoned piece of property, there wouldn't be anywhere left in the city of Royal.
Right.
So that's something we couldn't do. So
Now, you might as well just opt out. You know what I mean? If you're going to not allow any of them anywhere.
But those restrictions have to apply equally to each license type?
no, they could vary. We could have different setbacks for different types of establishments.
Okay, I'm still trying to understand, how is it that they all have to be, there has to be an opportunity, if you opt in, there has to be an opportunity for each of them, or we have to design an ordinance that applies to each of them?
From a zoning standpoint, we would have to allow somewhere in the city where each one of those types of license would be permitted. And that's assuming they meet all the state criteria, they get all their qualifications from the state. If we're going to have our own licensing ordinance, they're going to have to meet all the requirements of our licensing ordinance too. But the point is that we can't provide for a type of license that, from a zoning standpoint, there's nowhere in the city for it to go.
Right.
Yeah, so to layer on that question, I'm sorry, Commissioner Dubois. So in the event that we create zoning which enables at least the possibility for each type of license category, on top of that, is there the ability to say, okay, well, we're also going to put a cap on the number, so it'll be 1 grower, but 2 transporters or whatever it may be? Is there the ability to layer in that sort of scenario.
Yes, you can, but again, then that raises the issue though of if you're only going to allow 2, and there are 3 or 5 or 10 that make application to the state, and they meet the state requirements, then it falls back upon us
Sure.
to have a system in place to choose which 2 out of those 3 or 5 or 10 are the ones that are actually going to get a license
Yeah, sure.
here in the city of Rilo.
But you could, so that if we so decided, we could layer.
Correct.
Okay.
So I just want to make sure I'm clear on this point before we move forward. So we could say 1 grower, 1 transportation, 1 micro business, and 1 provision center. The way that we design it could allow for 1 of each of them.
One of each of the 6 different classes of establishment.
We could do that through zoning or just through ordinance saying we're allowing 1 license of each type.
Correct. Correct.
And it
We
does have to
allow
be.
for at least 1 somewhere, in theory, in the city.
In
It doesn't mean that there has to be a property available at this moment. If we were to say, hey, it makes sense to have a processing, more like a manufacturing setting, and there's no available real estate at the time, that's okay. It's still available if someone were to make the financial pitch to acquire a piece of property there or enter into a lease agreement, correct?
Correct.
Okay.
Commissioner Macy?
So I'm as surprised as I feel like Commissioner Dubak is by this, because this is the first time that I've understood that we have to allow each kind of establishment if we allow any of the establishments in here. And it seems for Royal Oak, which is a good-sized city and has different zoning, it seems like that would be feasible, although I think quite difficult to craft an ordinance that's going to allow this. But I guess what's confusing me is it seems like there must be some smaller communities that wouldn't want some kind of like an industrial zoned, you would think, operation like a grower, if maybe they don't have a very large industrial, or maybe they don't have any in their city. So I find that's a really strict and strange provision of this, and I wonder if they're open to any feedback on how we're interpreting this. I mean, have we talked about this in particular? I feel like we've heard quite a bit, and this is the first time I've understood this.
Well, I mean, I think that's one of the significant differences between the MMFLA, the Medical Marijuana Facilities Act, and the Adult Use Recreational Establishments Act. Because again, in the first act, we can pick and choose.
Right.
But in the second, we can't. And I think that's consistent with the information that the planning department has received at the training and the seminars that their staff has gone to as well. So.
I feel like it changes a lot how I'm thinking about this.
So I guess, in terms of the smaller community that you're talking about, I mean, if they don't want to allow for a grow operation, then I think their option is to completely opt out.
Yeah.
Even though they may want a retail
That was
establishment.
my understanding until this moment.
Yeah, that was my understanding.
I mean, I could do some more research on that particular question, but, you know, that's the way I read the act, so.
And believe me, I'm just surprised.
Yeah.
I just didn't know.
Mayor.
Commissioner Dubak?
Yeah, I just want to echo that it completely changes how I've been perceiving this, that we're going to have to craft something that allows for all the different types. And that's not something we've discussed before, right? I'm right to be surprised by that information?
Oh, we haven't really discussed it much at all, period, before, that's why we're here tonight.
Well, I think during the educational session that we had, certainly I remember the presentations where we had, our experts come in and explain the different types of establishments. I don't think any of us connected the dots that, well, if you opt in, or don't opt out, rather, in this particular case, that you'd have to make provisions for all of those. So I think that is, maybe that wasn't completely understood at the time, but it doesn't, it's a new fact and adds to our calculus now. What do you think about this?
I mean, I guess I'm just trying to think of something that we could compare it with. I mean, I guess in terms of maybe, just for example, some kind of a very heavy industrial use. Generally speaking, you may not want that heavy industrial use in your community, but you still have to allow for it somewhere. And even if you put it in a very small general industrial district in one part of town and you make it subject to a special land use, where a number of other criteria might have to be met, you still have to allow for the potential for someone to have that use somewhere in your community. Doesn't say you have to allow it, the potential has to be there.
Right.
Okay, well, I've got that on my list of questions, so I can pull the specific language out of the act. And again, and there was a webinar that the Michigan Municipal League put in that Tim and his staff and James and I sat in and listened to, and I mean, no disrespect to the people at the MML, and I know the general counsel is a former partner of mine, but we're at a point now where nobody can really give any definitive answers. So there's a lot of gray area here, and kind of like the original MMMA, a lot of the answers are going to have to be, they're going to have to come from judges. It's going to have to be in court. Those questions are going to have to be fleshed out. So.
I don't think the statute answers.
Any more questions on the background or what's in or other dynamics related to the two acts? Okay, I think this brings us to the Cobalt survey results, which we had a pre-indication of.
If I could, Mr.
Yes.
Mayor, there's one other area that I think I need to talk about as
Sure.
long as we're in that area, and that's the emergency rules that were just promulgated by the Marijuana Regulatory Agency, the MRA, which is a division of LARA. And those were released on January 3rd, so just a little over 2 weeks ago. I'm sorry, July. Yeah, thank you. Yeah, you think I was in Europe on vacation? Yeah. But the purpose of the emergency rules was to provide for the implementation of the MRTMA and to provide more guidance to kind of put some meat on the bones, if you will, recognizing that the state has indicated that they're going to start accepting license applications as early as November 1st. So this was then meant to kind of fill in a lot of the gaps. So from the municipal attorney's standpoint, this is the last piece of the puzzle that we were waiting for before we could really start to have these kind of discussions with our clients. I mean, it's 64 pages of rules, some of which applies to municipalities, some of which doesn't. But I think probably the most significant point for purposes of our discussion tonight and going forward, at least in the short term anyway, is that the emergency rules created 4 additional types of licenses under the MRTMA. The first is a marijuana event organizer, which, for lack of a better definition, just in terms of being simple, is basically someone that is allowed to put on special events involving marijuana. It's a marijuana focus. Specifically, and this is the second type of license that was created under the emergency rules, is a temporary marijuana event. And a temporary marijuana event allows for on-site sale and/or consumption of marijuana and marijuana products for a period of 1 to 7 days. So again, it's somewhat akin to the special event permit that we have now here in the city for a variety of other events. But this is something specific to the adult use and recreational marijuana industry. There's also a provision for a license for a designated consumption establishment, which, again, for lack of a better word, and to try to boil it right down, is basically a marijuana bar. I mean, instead of going somewhere and getting a beer or a cocktail or something like that, a designated consumption establishment is someone who is over the age of 21 is allowed to go to specifically consume marijuana products, either smoking them or edibles or anything like that.
Mr. Gillen, in that particular case, is that also be a retail establishment or be specifically a carve-out where that use is allowed at that establishment? So like right now, I mean, just to use a very basic, naive example, you can go and order a beer at the bar and sit down, right? And it's all within the establishment. To me, that seems like more of a retail nature. You know, I guess at the bar I can't take the bar. I guess maybe I could, but you wouldn't take it home with you, so to speak. So there are some differences, but in this particular case, it'd be interesting to know, is it, you just go there and you're allowed to consume it there, like you bring your own? Or is it also allowed to procure it on site?
Yeah, it's a good question, and I should know the answer, but I don't, I'm drawing a blank. So again, that's one where I'm going to punt on. So.
Commissioner Macy?
I was on that webinar too, and I believe that you retail sales as well, so it's
Permitted
retail
there,
and
okay.
use.
Okay.
Commissioner Douglas?
So there are the 6 categories that if we allow one, we have to allow them all, from grower to retail establishment. Is that also true of events and consumption establishments? I mean, that is, if we allow the original 6, do we also have to allow events and smoking bars?
There are really 8 now.
Well, actually, another one too, because there's an excess marijuana grower license, which is really for someone that has a huge number of plants. So, but that is another one that's created. But to answer your question, Commissioner Douglas, my opinion, no. Because the way the act is written, it talks about a municipality's ability, saying that they may adopt an ordinance that allows for temporary marijuana events or for the operation of a designated consumption establishment.
Okay.
So I think that's one where we're not tied in to say yes, because that's not one of the 6 classes of license that was created in the act. Those are permitted. They're a may, not a shall, if you will.
Okay, thanks.
Commissioner Gibbs?
My recollection from the webinar and from my reading and from my reading of this, but also various other articles on the consumption, it could also be combined with the retail, the sale of. But that also means that it's not allowed outside of that particular establishment. So it's, you know what I mean? It can be regulated as to, it has to stay within, you can't serve alcohol, you can't serve pop, you can't serve soda if you live in the South. Or you can't sell potato chips. So if you want to go to Taco Bell, then you gotta get in your car and drive away. So.
Yeah, I think, I'd agree with that, and I think as a general rule too, the sale of food on at any of the licensed establishments, I think that's also prohibited too.
I believe
Say
so
food,
as well.
I mean the marijuana infused food, or just food in general that isn't a product?
Marijuana infused food is not, quote, food.
Okay.
That was one thing we did learn during the webinar.
Right.
That's for sure.
It's product.
It's product, right.
It's product.
But other than that, if it doesn't have something to do with marijuana, again, my understanding is you can't buy it and eat it at that location.
Commissioner LeVasseur?
Talking a little bit more about on-site consumption, I'm trying to determine the similarities and dissimilarities between this and alcohol establishments. We could go to the brewery and buy a beer or two and be perfectly fine to drive afterward. Is there a certain amount of consumption on site that is allowed and someone could still drive after the fact? Is there a certain time period? Is there some way to measure? This might be a question for the chief. I know he's researched these issues.
And just to add to that question, maybe like a serve safe, like they have at liquor serving establishments.
The simple answer is there's no set limit, there's no kind of timeline, established timeline that we have for alcohol. So, enforcing of driving under the influence of marijuana is very, very challenging. And marijuana affects everybody differently. So there's not one standard to use. My recommendation is don't drive if you don't smoke anything.
Just to follow up, my recollection, Commissioner, is that as part, and remember, these are state licenses that people would be applying for. They're not local licenses, but it's a question of whether or not we want to have an ordinance that allows that activity in the community. But as part of the state licensure process, there is a requirement that the applicant submit some kind of a safety plan to offer some assurances, basically as to make sure that people aren't going to be overserved at those kind of businesses, those kind of establishments.
question is, do we have some other ability in addition to that to regulate driving from, say, a micro business where there's on-site consumption, to put some additional requirements upon the vendor in that instance, to ensure safety for the public?
I don't believe we do, no, although we do have some general authority. Either the state or local law enforcement does have the authority, at least in the case of a temporary marijuana event. I'd have to double check as far as the consumption establishment is concerned, maybe not, but for a temporary marijuana event, if local law enforcement concludes that continuing the event is going to cause an immediate danger to the public health, safety, and welfare, they can summarily come in and shut the event down. I know that doesn't really technically answer your question, but that is some authority that we do have under the administrative, the emergency rules, to try to cut down on the type of problem you're talking about.
Commissioner Gibbs.
My understanding is that the state requires video cameras and all kinds of recording devices in each and every one of these various establishments. Is it possible, and this I have no idea, is it possible for the city to require that the police department be able to access those for monitoring purposes? Not that we're necessarily going to be monitoring the entire business, but, you know what I mean? To make sure that people aren't buying more than what is allowed, or whatever the case may be. Do you know? Or maybe Chief, you know?
I would just, under MLCC regulations, any licensee is required to cooperate with police. I would hope would have some sort of ordinance or rule that they're required to cooperate for all local, but that includes turning over their video when they have video that we need to see. So I would hope we could wrap that in. Now, I don't think the police department's really going to be regulating those kind of whether or not someone was sold too much or not. I don't know. That's really the police department. The state may have an interest in that. I don't know that the local police department is going to be able to do much about that, because there's aspects to this where you can have 2.5 ounces of marijuana for personal use. We talked about the medical marijuana. Then you can buy your medical marijuana if they're licensed under both, and then you can help somebody else with their, so you could potentially purchase for somebody else, and that's all those things have to be worked out. So.
Yeah, I'd agree with the chief. I think that's probably going to be more of a state issue than a local issue, but I guess I just would make a general comment that, and I know, and the chief is correct, that the state does require liquor licensees to cooperate, but but I think generally speaking, liquor licensees here in town are more than cooperative with the police department in terms of providing video and things like that if there are incidents or complaints. I mean, it's something that my office is normally asking to review, and it doesn't seem to ever be a problem for the police department to be able to get that. I mean, I think that's a compliment to the chief and the relationship that his department has built with the businesses here in town.
And I wasn't trying to say that the alcohol establishments in the city didn't comply. It was, you know what I mean, just questions that we'll need to figure out.
I had Commissioner Douglas.
Yes, Mr. Gilman, you mentioned that the state anticipates being able to start accepting license applications November 1. How quickly do you think they will turn those around? And knowing that there are some medical marijuana licensees that you seem to think will maybe get a fast track through the state, how quickly, and I know this is just going to be pure speculation on your part, but how quickly do you think they might have licenses issued for adult use?
I mean, the statements that the head of the MRA indicated last week was that they were bringing enough people on board that they'd be able to turn around the license applications very quickly. So, I mean, I think if we stick with our February 1st date, I would expect that there are probably people that will be through the pre-application phase of the licensing at the state level by the time our ordinances become effective, or the opt-out is no longer effective, if you will. So.
Okay, good, thank you.
Mr. Perush.
Back to the 4 new categories that the rules created. Those licenses are issued by the state.
Correct.
It just seems to me then that in our own ordinances, zoning and licensing, I would assume we're going to have to deal with those 4 as well. We can't be silent on those 4, because if someone gets a license from the state to have a special event and wants to hold it, oh, we want to do it in Memorial Park, we're going to have some mechanism in place to say, no, you can't do it in Memorial Park. This is the only place where you can have a special event license. If our ordinances are silent on it, does it give them carte blanche to put it anywhere they want? In other words, it seems to me that we're going to have to not only develop language for the original 6, but also the new 4 in terms of where we want those to occur or not occur.
And those were, maybe this would be a good point to wrap up this part of our discussion. But the questions that I was going to leave for you in terms of the licenses created by the emergency rules, going forward, do we want to allow the temporary marijuana events? The rules do specifically require some fashion or another of local approval of the specific location where the event is supposed to take place.
Okay.
So that's kind of opens up the door to a related question that we've talked a little bit about with the planning department as to whether or not we want to deal with those under our special event ordinance, or do we want to try to deal with those from more of a zoning standpoint? So something else to think about. And along the same lines, if we're going to be allowing the designated consumption establishments from a zoning standpoint, where do we think we want to potentially allow those, if we're going to allow them? But again, I don't think we have to.
Just a little clarity.
Commissioner Dubuck, did you?
I'm good.
Okay. Commissioner Wilson.
Thank you. Just a little clarity. The Recreational or Adult Use Act basically provides that if you don't opt out, you have to allow at least one of each of the various categories, you know, the growing facility, the processing, retail, microbusiness.
One of the 6, yes.
One of the 6. Now we're talking about special events. Is that also required, or is that something that we as a community could say, okay, we'll allow those 6, but we're not going to provide for special events?
In my opinion, the special events are discretionary, because the way the statute is written, the act itself, not the rules that were issued pursuant to the act, but the act itself talks about a community may provide for the special events and the designated consumption establishments. So I think we could say no to those, and then potentially say yes to 6 under the act, the 6 actual license classes under the act itself.
Just to follow up, so silence on that subject would mean we did not allow them? Or do we have to say we forbid them? Because it says we may, so if we don't, then that applies denial. Yes, no?
My advice would be, if we don't want them, that we say that we don't want them.
Okay.
You don't want them coming to the planning department, the police department all the time, you know, looking for an event, just to bring them up here and deny them, you know, on a routine basis, so if we go through the special event permit process.
Okay.
Yes, Commissioner Dubuck?
I'm sorry, I'm still
You're
struggling.
wavering on your unwavering opinion.
I'm still struggling with what has to be. So the closing statement on the letter from tonight says, a municipality may allow any, all, or none of these 5 types within its geographic boundaries. So this is why I was a little confused. It implies to me that we get to pick and choose between the license types.
I think that's MRTMA, that's
Medical.
recap. That's the medical recap.
Okay.
Yeah, which of the memos were you looking at?
Oh, you're right. Okay.
Because there's 6 for the recreational adult use.
That's why I was confused.
Yeah.
Thank you.
Just to, generally to take a step back and to see how we on staff are envisioning this at this point in time, whatever direction the commission decides that it wants to go, we're looking at really 3 layers of regulation by way of ordinance. One would of course be the zoning ordinance, which we talked about, and the zoning ordinance provisions are something that's clearly permitted under both of the pieces of legislation. The second would be some kind of our own licensing ordinance, which would involve probably a couple-step process. The state law does allow for an applicant for a state license to obtain basically pre-qualification. And then they have the ability at that point in time, if they want, to go out and obtain local approval and then also firm up the details as to where it is they're exactly going to be in terms of acquiring property or leasing property or whatever. So I think what a number of communities have done, and I think what we would probably be recommending, would be that one of the requirements of our licensing ordinance be that an applicant have been pre-qualified by the state. Because then the state requirements are pretty rigorous, and by doing that, by relying on the state, that would do a lot of the weeding out, if you will, no pun intended. But that way we would know that anybody that came to the city that was pre-qualified at the state level, if they met our criteria and we were in a position to go ahead and issue them a license, that we could feel confident that they would actually end up getting a license from the state at that point in time. So that would be the second level of regulation. And the third would be more just of a general amendment to some of our criminal ordinances, because violations of our ordinance and also violations of the state law, we could make those violations of our ordinance. There are some limits in terms of the penalties. Most of them are civil infractions. But there are things that we can prohibit on a local level from a criminal standpoint. So those would be the 3: zoning, licensing, and then also general amendments to our offenses ordinance. So, and that might be a good segue. I know that Tim's staff has been working on a zoning ordinance draft. He wants to maybe run over that with you and give you an idea. I think we had given a copy of that to you.
Well, basically what was included in your packet was a very rough draft to touch on some of the things that Mr. Gillum brought up to try and, I guess, drive the conversation of where do you want to allow, if you allow, either facilities or establishments in Royal Oak. So obviously that's the first part of it, and the text talks about several options that's to the commission in terms of what districts you may or may not want to allow certain facilities or establishments in it. The emergency rules came out with a table that kind of treated them similar between the acts, so staff was looking at them in that fashion as well, trying not to reinvent the wheel. So that's one of the big directional items that at some point we'll need direction on. In addition to that, the process that ultimately will be used to review and approve various applications through the zoning ordinance and who has final say. A lot of the special land uses that are listed in the zoning ordinance end at the planning commission, meaning they never arrive at the city commission for any sort of input or consideration. Given that potentially we're talking about a licensing ordinance similar to a liquor plan of operations, we're thinking that the best way would be that any of those facilities or establishments would be a special land use that would go through the planning commission and hold the required public hearing, get a recommendation, but the final decision would end at the city commission as you're dealing with the licensing issue as well. So that's kind of one of the thoughts that's driving through the ordinance as well. If you concurred with that, then fine. If you needed a different process, as we bring this ordinance to you, you'll want to look at that. Then some of the other things we're looking at are separation requirements or the setbacks that were brought up before, both from various institutional uses as well as the facilities or establishments themselves. Do you want them so far apart from each other? Do you want them on a certain size property? There are a lot of ways to narrow down where you can and would allow any of these uses to occur. The one thing we did not put in this option, and it was based on staff's review of other communities as well as the Cobalt survey, is we're not allowing any of these in the CBD or the Central Business District. Just because we think that's going to, we can get into that more as we go through future meetings or public hearings, but that's one of the districts you'll see that, other than residential, but any of the commercial or industrial, the way it's been put together so far is none of them would be allowed in the Central Business District. Again, some of the approval processes, whether you wanted to consider waiver of certain requirements, would end up at this table. So there are a lot of the actual provisions as we bring the zoning ordinance text amendment to the City Commission you'll want to consider. Having said that, there's a very formal process to amend the zoning ordinance. The public hearing is held at the Planning Commission. And then the Planning Commission would give a recommendation to the City Commission. One of the concerns I have is with your February deadline is when I can start that process at the Planning Commission, because I'm already in September. And I don't believe it'll get through the Planning Commission's public hearing in one meeting. So, and not to rush the issue, we have all kinds of time, but I mean, you can extend your February deadline and that sort of thing, but we're kind of getting at a point where I need to start this formal process to get it in front of you and still try to hit a February deadline unless there's some comfort level that you're going to know that. I just bring it up now so it's not a surprise in January that we're not ready to give you an ordinance if we delay when I can start at the Planning Commission. I guess the ordinance itself is one item as far as the text. Mr. Gomes touched on the other uses that have been included in the other establishments that have been included in the rules. We're probably going to suggest if you allow the temporary events, that those be done under a special event, and that the ordinance simply gives you that discretion under the special event ordinance. And you can have police review of them, you have a little more control with them there too. So, we are looking at, and those new ones that came out of the rules that were just released, we're still working with how to put them into this or deal with them. Again, it's planning staff's assumption that based on the vote of the community and indications from the commission, we're going to allow some type of this to move forward. So we've started that draft. And again, my only concern at this point is whether or not we have enough time between now and February to get through that formal process without extending it.
So Commissioner Douglas?
Yes, why not allow, for example, at least retail establishments in the CBD?
Well, I can touch on a couple that have come up. The parking demand for these facilities are quite high from what I've heard is occurring in other communities. They also have a tendency to drive rents up and drive other retail establishments out in those facilities because of the ability to do certain things. And then there are other impacts that I can touch on at some point. But and then the Cobalt survey itself from the community said you didn't want them downtown. So those are probably the biggest three reasons, but there are others.
And continuing, in the Cobalt study, we asked people about the types of regulations they might support to control establishments. How many, which if any of these are allowable considerations for special land uses?
I don't recall all of them. Any of them that have to deal with use provisions, land use provisions, setback provisions, parking. There may be some that are better off in the licensing ordinance if they're more about how it operates, rather than in the zoning ordinance. If you want to limit the hours, I don't know if the state's going to limit hours, but if you wanted to limit hours, that might be something you put in the licensing and not in the zoning. So I don't recall all of the things that were listed in the Cobalt, but depending on what they are, they fit better in one place or the other.
Okay, so we haven't really talked about licensing here, and that's later on in the agenda for this subject, but since we're talking about licensing, so the state will issue licenses, but then cities can, or communities can also establish a license with additional, let's say, restrictions?
And Dave can talk about it too, but my understanding is we may be able to review those on an annual basis, just like the state is. So that if you have certain provisions that you want to check on that annual basis, you can do that. But that's more of an operational issue than you've been approved to be here.
So, but I thought I read somewhere that, that there are limits on how communities can limit these operations. So, and maybe you want to discuss this, because I know you've got licensing on the agenda. Is that a more substantial discussion about the types of licenses we may issue, or is this a time to ask that question?
Well, in terms of the types of licenses,
I'm sorry, not types of license conditions.
I know that may be kind of a separate issue from the zoning ordinance issues we're talking about right now. So,
But that is, will we discuss that at more length as part of tonight's discussion?
well, I don't have a sample licensing ordinance for you or anything like that at this point, but we can talk about the general things that we can't try to regulate through a local ordinance. And then there's some general language in both of the acts that talks about the things that we can, or the limits on the types of things that we can regulate.
I'll hear that. Because, that means that in addition to changing our zoning ordinance, which as Mr. Twing says, you don't do it like that, it's a process. There's also a process for writing and approving licensing that's going to have to go along parallel to that, right?
The licensing ordinance, correct.
So.
That's not going to be through the planning commission.
Right.
But yeah.
Okay.
Yep.
So, lots of stuff to do before February 1st.
Yes. Yes.
The issue. Okay, good, thank you. Thank you.
And not just those things need to get done, but there's very formal and time-sensitive processes that need to be followed.
Right.
Are just checkpoints, and planning meets once a month. You miss your shot by a day, then it pushes everything out. Commissioner Macy.
I just wanted to clarify that, well, the Cobalt survey showed that in general, the 5 of the establishment types were people strongly didn't want them downtown. It was a pretty close call for retailers, with 49% saying yes, they would want them downtown, 45% saying no, and 3% unsure. So that's one thing about the CBD. I also think, the concerns that I heard about parking demand, we can't still be talking about parking in our downtown. We have thousands and thousands of spots. There's plenty of parking in our downtown, maybe not street parking, so we should think about how that will be affected. And then in terms of driving up rents, can that be a concern when we're limiting the number of licenses? So if there's only 2 and they're out there, should that be driving up the rents of the others as well?
I would argue that we can't, the caution that Mr. Gillen gave is that if you limit the number, you can limit the number through zoning, meaning that, if there's, let's just say, for example, it meets these industrial requirements and it's you know, you have to have this setback, this square footage, that limits it to 8 potential buildings in this area, okay? So you know maximum you'd have 8 licenses or whatever for this particular area. But if you put a cap and say 5, the risk is that even in your downtown, let's say you say, you know what, we're only gonna have 3. Well, the risk is that, you know, number 4 applicant, you know, is going to, you know, you're at risk for some sort of litigation. Because at some point, the commission would have to decide, if you have 3 and you've zoned it, and you're only capping it off at 3, you know, and you have 30 applicants, and they're all qualified with the state, and they all meet your criteria, how do you distinguish, what's that process you go through to pick that, versus if you said, you know, I guess you could say it could be in the downtown, and it has to be minimum square feet and all this, you could go that route and say, well, that leaves a maximum of 10, but I think in our downtown, it's a little harder to do that than other parts.
I mean, I completely agree with your point. I think we're gonna face that problem no matter what. I just am not sure that the CBD is what makes the difference for that. I can see it's more in demand, but I'm saying that I don't know that I would take CBD off the table right now. I think it's something we haven't discussed at this table really at all, and we haven't heard a definite no from the community. It's something we should consider.
Anybody else? Commissioner Cobalt.
Yeah, to Commissioner Macy's point, I think what we're doing here is because of the overwhelming mandate we saw in the 2018 election and has been confirmed, you know, to some extent by the community survey. We should be having an honest conversation about all options, learning all the options, and then deciding which way to go and not writing things off the bat here. I do think there's some legitimate concerns given the drop of support in the community survey, and that needs to be part of our calculus as well as the concerns raised by Mr. Thwing. But I'm not at a place where I'm willing to make any decisions or say anything's on or off the table right now because we're still information gathering, and I think that's the right approach.
Anybody else? Mr. Carney?
What's that? I didn't.
No, just, there's no other questions.
And Mayor, we did have a closed session scheduled tonight.
Mr. Douglas.
I don't know if the commission wants to forge ahead right now, if we want to break for our closed session discussion, or it's the commission's decision.
Well, I think maybe we give a little bit of guidance real quick before we break to our closed session about sort of expectations for the next, I think clearly we're going to have to schedule another session, work session. We have to have time here for some public comment, so we're going to have to open up public comment. Unless we do it at the beginning of our
Regular session?
Yeah, okay, we could do that. Yeah, we could do that. So, actually, okay, I think we could probably do that now. Take a quick break for our closed session, and then we'll come back and pick up where we left off. I don't anticipate we'll be in closed session for more than 15, 20 minutes, 30 minutes max.
We had scheduled a half an hour, but
Maybe it's quicker.
we were thinking that would be more than enough.
Okay, so we got a lot going on tonight, everyone. But what we're going to do is we're going to take a quick break. We're going to go back there and discuss some attorney-client privilege information. We'll be back out to finish the rest of our agenda that we have for this work session. And then after we conclude the work session, we'll jump into our city commission meeting immediately. So enjoy the scenes, get something to drink, shop at one of their many retailers that are open with the power outage. It'd be great.
Or the air conditioning if you don't have it.
Yeah. You don't have it. Go wash your face sometimes if you
All right, ladies and gentlemen, we're done with our closed session. I think we've decided that we're going to do something here. We have a very light, regular city commission meeting this evening. So what we're going to do is we're still going to keep the work session paused. We're going to jump into our regular meeting, which is really at this point, one agenda topic, which is the consent agenda. There may be one or so added, but that meeting would go relatively quickly, at least from a discussion point up here. And then what we will do is we will jump back into our work session and continue that as long as we have to. So there'll be an additional, few minutes here for us to get through our regular agenda. So with that, I'm going to call to order the July 22nd, 2019 Royal Oak City Commission meeting to order. We're going to begin with the invocation given by Commissioner LeVasseur, followed by the Pledge of Allegiance. Please stand if you can.
As we gather here, let us keep in mind the purpose that we are here for. That is to serve the residents of our community and to look out for the best interest of our city. Let our decisions, our thoughts, let the direction that we take always be guided by those concerns. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, for those of you who don't know, we do have air conditioning. We have a generator here, so we do have limited power and limited technology here, so we appreciate your patience this evening. This brings us to item number 4 on the regular agenda, which is public comment. The City Commission does rely on the input of fellow citizens so that we can make informed decisions here. Tonight, at this time, is your opportunity to come and speak what you have to say, both on any item that is on the City Commission agenda tonight or not. Because we want to hear from anyone who wishes to speak tonight, comments are limited to 3 minutes, and there used to be a timer at the podium. Is it still working? Okay. Well, I will help you with your time. Oh, there it is. We have some Phoenician or Egyptian mode of calculating time, so it's not working. But we'll do our best. I'll just raise my hand here when we get close to the 3-minute mark, so you know. Please don't think that we're being rude, but we want to make sure we have an opportunity to hear from everyone tonight. I ask that you direct comments to this commission as a whole and not to individual commissioners. So with that, who's first? Mr. Gomez, I see you back there with your hand ready to go.
Evening, George Gomez, 2018 Guthrie, Royal Oak, Michigan. I'm actually here on behalf of the Optimist Club. I wanted to start this off with a positive thing. We are here to thank the city, as well as your Greg Rassel, for working with us. Over this last year, we have installed 2 bicycle pedestal stands, since it's become such a great activity here in Royal Oak, and we wanted to announce that to you. One is in front of the Boys and Girls Club, and recently the last one got installed in front of, well, it's at the backside, but the entranceway to the library. So we do want to thank you. On behalf of the Optimist Club, we think that's a great gesture for the children and the other folks in the community to enjoy, so we appreciate your support.
Thank you, George. Thank you, Optimus. Good additions to our community. Yes, ma'am, I see a hand.
Good evening, Pamela Lindell, 409 Inglewood Avenue. I spoke last month about upcoming animal shelter fundraisers, and I can report that they were both very well attended and successful. The first one at the Oakland County Football, well, they play in Placid, but it's Oakland County, was a family, kid-friendly event with a bouncy house and face painting, so that was fun. We won, that was even better. The next fundraiser was the Texas Roadhouse. That's the second one that I've organized for the animal shelter. It was another family-friendly way to raise much-needed funds for our shelter. Shelter board members Travis Moore and Eileen Krupa both came, and I thank them for their support. Next, I was thrilled to hear Dog Days of Summer, the foodie fundraiser, proceeds are going to be going to the library. This will definitely help make up the thousands of dollars that the Friends Group is down from diminished sales in our shop and at our annual book sales. And speaking of library volunteers, many have been trying out the new structure, the new parking structure, and I'm sorry to report that these volunteers are being charged during their 2 free hours before 5 o'clock. Somebody needs to look into that. Thank you.
Thank you.
All right, who's next? I see a hand way back there. And I forgot to add, state your name and address.
Sorry, in here. Hi, my name is Judy Lewis, and I live at 1009 South Washington Avenue. I spoke last time, I'm speaking again, different tweak on this one. I'm here to talk about the apartments being built at 1003 South Washington Avenue, the side of the closed Chin Jewelry Store. I have no problem with new buildings. In fact, the more the merrier in Royal Oak, but the sheer number of apartments in such a small space is what concerns me. The builders said they want to dig underneath the parking but with 48 apartments, that could be between 70 to 96 cars, since they are saying it will be a family dwelling. And with visitors, where will all these people park when the surrounding neighborhoods are already congested with cars? Henry Ford is building a new complex right next door to City Hall, and there may be staff wanting to move to Royal Oak to be closer to work. Why not make the building mostly 2 bedrooms with no studios and a few 1-bedroom apartments, which would attract professionals, which besides paying their taxes, will also be spending their money in our great city. Thank you.
Yes, ma'am.
Good evening. I'm Nancy Sussigan, the president at Royal Oak Beaumont Hospital. I'm the new president, and I wanted to come introduce myself to you. I've been a registered nurse for 33 years, and I've been at the Royal Oak Hospital. Originally, I started as a staff nurse there and transferred to leadership positions at Troy, and then was a hospital CNO, COO, and president there for a number of years. Also, what I'd like to say is I proudly served my country at the United States Navy Reserve for 24 years. Worked as a staff nurse, so I stayed real connected to bedside patient care, so I knew what it was like to take care of patients at the bedside. Also, each year for the last 8 years, I led a Veterans Day ceremony, and I plan to do it at Beaumont Royal Oak, and you are all invited to come this year. 5 months ago, I was chosen to return to Royal Oak as its president, and I really think this is an honor and a privilege. Royal Oak is a great hospital serving this community, won a lot of different quality and safety awards. Number 2 in Michigan related to U.S. News and World Report, and also ranked nationally in many multiple specialties, and we also are magnet designated, which is highest award a nursing organization can receive. Our Chief Nursing Officer and Chief Operating Officer are both nurses. I think it's important to know that I personally selected them. I believe nursing is the heart and soul of healthcare. Beaumont has supported this community in so many ways that I've been learning, but we can do so much more, and I want to do more, and I want to partner with all of you. We've assisted with senior transportation, a number of events, and so forth, but there is so much more. Woodward Corners open soon, excited about that. There's many health and wellness initiatives. There's a healing park, healing gardens rather, and walking paths and so forth that are going to be open for the community. We also recently received a federal grant to establish a medication-assisted treatment program for opioid addiction, and we'll be partnering with our community for safe transitions into the community. In announcing the grant, Governor Whitmer thanked Beaumont for stepping up to this important health and social crisis. And I've talked to Judge Meineke also in the community about this issue. Recently, we also completed a community health needs assessment. Those areas, we had members from our community that were interviewed and were in focus groups, and there's 4 areas we identified we need to work on: heart and vascular, diabetes, obesity, and mental health. And we're going to be calling on our community to really help us design what we need to do for programming. Our Community Advisory Board, which our mayor is a member, will help keep us accountable to make sure we're meeting our goals. And then finally, on another note, I know there's been a lot of attention in the media with a group of Beaumont nurses who want to unionize and a group of nurses who do not want to unionize, do not want to be unionized. Beaumont's a great place for receiving health care and to work. Our incredibly strong nursing engagement scores, low nursing turnover, low vacancy rates has really proven that this is a great place to work and practice. I've been listening to our nurses since the first day I came here 5 months ago, and all points that I've shown above are definitely coming true. At the town halls, I want to make sure that I prioritize what the nursing issues are. I've encountered a large number of nurses who are asking questions about their legal rights, unionization, and unions in general. As a nurse, I'm an advocate for nurses, and as a president of Beaumont Royal Oak, it's my duty and responsibility to ensure our nurses have fact-based information so they can make informed decisions about this more important matter. We're educating our nurses on the National Labor Relations Act and National Labor Relations Board according to their materials, which is published. You may have heard You may have heard that at times nurses are being asked to go to education sessions, and they are. They're open to all nurses. Patient care is never compromised. That's my #1 priority. Those who choose not to participate, that's fine. There's not been any discipline, and there will not be. You may have heard that M&A supporters feel their rights have been constrained. However, they have tables set up in our cafeteria, our lobbies, and many other places in our facility daily, and our hospital, providing union information to those who request it. I'm happy to discuss any issues or ways to partner at any time with any of you or anyone in the community. You have a caring nurse leading your hospital with a reputation of listening and collaboration. Thank you.
The gentleman here in the room.
Good evening. Mark Sackett with Michigan Red Sox doing the refurbishment or improvements to Memorial Park. We spoke last end of March, working diligently to get this thing done. Everything's right on track from our standpoint. We are hoping to break ground on September 3rd. About 3 to 4 weeks to do the earthwork. It'll be about 3 to 4 weeks to put the turf in, and should be done by the end of October if everything goes right with construction. We are just working with the building department, now getting approvals there, and we are working with Dave Gillum about the agreement we have and everything. So, like I said, it's pretty much on track, but I just want to kind of give you an update that things are moving, and talk to a lot of people in Royal Oak, and really looking forward to getting this thing done. So that's all I have.
Thank you, Mr.
Thank you.
We're all looking forward to it.
Yep, we are. Thanks.
Yes, ma'am.
Hi, good evening. My name is Sue Campy, and I live on South Washington, and I'm here to talk about the new development that's being considered for the property at where Chin Jewelers is, right next to the Washington building. And Judy already spoke once today, but I wanted to talk about, I think the city is making a mistake and being short-sighted on that opportunity, because I'll just tell you, I moved to Royal Oak at the end of April of this year, and I've been in the surrounding Detroit area for 30 plus years. I've lived in Rochester, I've lived in Clarkston, Waterford area, and my family, my children are grown, and we wanted to downsize, but we wanted to be in walking distance of a downtown, a vibrant downtown, and I looked at Detroit, Birmingham, and Royal Oak. Those are, to me, the only 3 choices that have a vibrant, walkable downtown. And Royal Oak is completely unique than those other 2 choices. And before this, my impressions of Royal Oak was a lot of homeowners on the periphery, and the downtown years ago was predominantly young people, predominantly rentals. A lot of people didn't take care, the properties weren't well taken care of, and that was the reputation of Royal Oak. A compliment to you that the city has changed. And I believe for the good. It's still diverse. There's still a lot of diversity here, but there's room on the 2 main streets that lead right to the downtown. There's only 2 main streets with developable area, and that's Main Street and Washington. And so to me, that's the portal to this city. It's right off the highway. Everyone who comes up that street gets their impressions of the city. And because there's so much still to be developed or renewed, you have an opportunity to plan and fashion what the front gate to Royal Oak looks like, and what kind of people live there and raise their families there and take care of the city and frequent the downtown. So I think that, I would say, I don't know your numbers, but I would say you've got to get a balance between apartment rentals and homeowners. And I can tell you, I've walked the neighborhood with my dog, and I've talked to neighbors, and the people who own their homes, the homes are better taken care of in general than the rental properties. You can tell who owns a home and who doesn't. So I believe that the other rentals that have come on, like the 855 building and the Griffin, those have been well thought out. They're beautiful buildings. They're not crammed into a space. They're not jammed up next to another beautiful building that's smashed up right next to them. And the problem with that property, South Washington next to the Washington, it's only a small corner. And that building is 4 stories, it's smashed right next to the Washington, and it's completely developed with no parking, so you have to go underground. There's a bunch of micro apartments. Okay, it's too dense for the area. It's overcrowding the neighborhood, there's not enough parking, and the city doesn't need to do that on these 2 major roads. I would be very careful and look at the long game, and be careful about what properties and what kind of development you want in these spaces on these 2 streets, and be consistent with what you've already decided.
Thank you.
Thank you.
Anybody else here? Mr. Wolf?
Ron Wolf, 3 North Troy. First, I want to say I'm not against medical marijuana in any way. Number 1, what is to prevent a school or a church from accepting a substantial donation from an applicant wishing to open less than 1,000 feet from that church or private school? We know it's done with liquor stores. It has been done in the past. They simply get a donation and then they agree it's okay. Number 2, a Pandora's box of lawsuits costing this city is possible, in the thousands of dollars, is possible if the city is named. Why damages, I say for this, in this respect, could be in the hundreds of thousands of dollars. Once you open up this box, you can't close it. Is THC oil included in the licensing? Why? Vaping is an increasingly popular business, and young adults are mainly their target, underage, especially underage. They now represent the largest base of use of vaping, and the electronic devices resemble flash drives. So will retailers using supplies in THC oils be included in this? I also want to know that I know for a fact alcohol and marijuana are exponentially affected when you combine them. They're not just additive, and it's extremely debilitating to the ability to drive a car. As marijuana is not measurable in the blood, how are police justified in arresting and convicting someone whose alcohol level is acceptable, but due to combining alcohol and marijuana, somebody has resulted in a serious accident or even a death? Which is more important, making money for special interests, especially outside special interests, who largely do not live here, or the future health of your children? I'm very disappointed that candidates, and the opposition candidates, have not spoken to this issue tonight. Perhaps they're afraid of it as a hot button issue. Therefore, I'm declaring myself to be independent, and I will not support any of the opposition candidates until I hear them speak out. We know that bars must prove purchase of liquor, but who's going to measure and who's going to find out how much marijuana is supposed to be in these retail establishments? And also, presently tonight, I noticed a vast majority in the audience who are applicants. Not one parent has gotten up to speak against it. On my site, as I said, I've invited the opposition. None has so far spoken up. Why can't the city vote right now? Why does the city have to vote right now, and why can't it wait 3 years? Birmingham has turned it down. Rochester turned it down. Recently, Roseville, adjacent to a very high crime area, has turned it down. I wish the camera would pan to the audience, and you will see who's interested in opening businesses.
Thank you, Mr. Wolf. All right, who's next? Anybody else? Going once, going twice? All right, we're going to close public comment, bring the discussion back to this side of the table. We will have an additional public comment session at the end of our work session as well when we get back to that. So this brings us to item number 5, which is the approval of the agenda. Commissioner Dubuc.
Mayor, I'll move to approve the agenda with an amendment to add item 7, discussion on interim city manager.
Is there a second by Commissioner Douglas?
Oh, discussion on special work session to regarding interim city manager? Yes, special work session, right, sorry.
Work, special meeting, I said the wrong thing, special meeting. Sorry, I should just.
So many meetings
Just
happen.
discuss it, you know?
Commissioner Macy, would you like to make the motion?
To clarify, item 7, discussion on a special meeting to discuss interim city manager contract.
I support that too.
Thank you.
Everybody's supportive and everyone's clear what the agenda now is. All righty, any discussion on the agenda? All right, with none, I'll call for the vote. All those in favor say aye.
Aye.
Those opposed? Motion passes. This brings us to the consent agenda. Does anyone wish to pull anything off the consent agenda for discussion? Commissioner Perush.
I'll move approval of the consent agenda.
We have a motion by Commissioner Perush. Is there a second? So a second by Commissioner Macy. The consent agenda now consists of City Commission meeting minutes from July 8th, 2019, claims July 16th and 19th, approval of purchase orders, approval of license agreement for 1221 East Lincoln, contract modification, 2019 library facade improvements, contract modification, professional engineering services, 2020 asphalt resurfacing improvements, contract modification, contract CAP 1915-2019 asphalt resurfacing improvements, Commission for the Arts, recommendation, Eagle Plaza application for public art, request for extension of due diligence period, 700 South Main Street, receive and file the following non-action items, the June 2019 Franco Project Activity Report, and the 2019 second quarter training and evaluation reports. Any discussion on the consent agenda? All right, with none, I'll call for the vote. All those in favor say aye.
Aye.
Those opposed? The motion passes. This brings us to added item number 7, which is discussion of a special meeting regarding the interim city manager contract. Commissioner DeVoe.
Thank you, Mayor. Pursuant to our discussion in closed session and to multiple conversations we've had at this table since Mr. Johnson had announced his retirement, City Attorney Gillum has been in conversations and negotiations with Mr. Johnson and has some terms to present to us, which we need to present to the public and have a formal meeting about before moving forward with consideration of those terms. So we just need to select a date for a special meeting to consider contracting with Mr. Johnson as an interim city attorney, or city manager.
Commissioner Perush.
The only thing I would add is the reason that we're having a special meeting or suggesting perhaps a special meeting is that the time frame between now and our next regular meeting is so long. That's just the way the summer calendar comes together this year. We wouldn't have a regular meeting again until August 12th. It's not fair to the staff who have been acting in an interim basis in this interim period, so to speak. We need some leadership, we need some decisions, and we need some clarity as to what's going to go forward. So we're not willing to wait another almost three and a half weeks for a regular meeting. So that's why consideration of a special meeting in the meantime is being considered.
So, dates.
Dates.
Next Monday, Tuesday?
We're thinking early
It's
next
Monday.
week, right?
Early
Yeah.
next week would be preferable. I'll be out of town Thursday and Friday.
I can do Monday or Tuesday at 6 o'clock, 7 o'clock.
6 o'clock is fine now.
Yeah, I'm pretty good on Monday or Tuesday, 6 o'clock.
I could
Can't do
either
both. Is there a preference of Monday or Tuesday?
Tuesday's problematic for me.
Okay, so you got it narrowed down to Monday. Anyone have issues with Monday at 6 p.m.?
I'd like to make a motion that we meet Monday at 6 p.m.
So you made a motion? or
For a
you'd like
special,
to-
for a special meeting to discuss an interim city manager.
Okay, we have a motion by Commissioner Douglas. Is there a second? Second by Commissioner Macy. Okay, so this is 6 p.m. Monday, special meeting. Any discussion? Commissioner LeVasseur.
And I guess this will be for our city clerk. How quickly could we post an agenda for this meeting and include a couple links to proposed contract, previous contract, that sort
I
of
can
thing?
speak with the chief tomorrow, because his office posts the agenda.
Okay. I'm going to move that we amend the motion and that by Wednesday of this week that we post the agenda for the public to see, and that we include 2 links, one which would be to the proposed contract with Mr. Johnson, and the second one would be to his prior contract with the city.
Motion by Commissioner LeVasseur, is there a second?
I'll
Second
second
by
that.
Commissioner Gibbs. Discussion? Commissioner Dubak?
Yeah, I'm assuming that city manager, or city attorney Gillum, or interim city manager O'Donoghue would be preparing a staff letter to go along with this item. I just want to make,
I'll be preparing the letter probably tomorrow afternoon.
so I just want to make sure that this gives you time to prepare your letter to make sure that there's context for the presented proposal.
Shouldn't be a problem.
Great.
All right, so this is a vote on the amendment to add 2 links in addition to the normal preparatory letter that staff will present to us. Call for the vote. All those in favor say aye.
Aye.
Those opposed? Okay. This brings us back to the original motion for Monday, the 30th? 29th. All right. Monday, the 29th, 6 PM for the special meeting. All those in favor say aye.
Aye.
Those opposed? Motion passes. All right, that brings us to the end of our agenda for the regularly scheduled Royal Oak City Commission meeting.
Motion to adjourn?
Motion to adjourn by Commissioner Douglas. Is there a second for that? Second by Commissioner Dubak. Discussion on the adjournment? If not, I'll call for the vote. All those in favor say aye.
Aye.
Those opposed? Okay. We're adjourned.
Point of order, just wanted to clarify the date of that meeting.
29th. Yeah. I confused it all by saying the 30th. That's me.
But it's Monday,
Monday the 29th. That's
not Monday 30th.
6 years from now, I'd be correct. All right, that brings us back to our work session discussing marijuana. And I got some squiggly lines here as far as where we left off. I know we kind of glossed over the Cobalt survey and kind of jumped into some of the community development discussions. Best place to restart, I know we even jumped down talking about special events and kind of licensing, so I don't know where, maybe Mr. Gillum? Mr. O'Donoghue? Where do you kind of want to start?
Most of what I was going to have to say, I think I have said. I don't know if Mr. Twing has anything to add in terms of the zoning ordinance amendments.
Not at this time.
I guess if there's specific discussion that you want to have relative to the Cobalt survey, maybe we should go back to that at this point in time.
Commissioner Macy.
I just got a zoning question for Mr. Twain.
Sure.
Okay. So I know that there was going to be an interactive map if we had all that power. I presume that you've looked at that and done the overlay, like had a kind of first glance of what the overlay looks like with the 1,000 feet around and everything. I'm just wondering if you can give us a little bit of insight what that map actually looks like once you've done that.
Well, the map, the interactive one was actually done by James through his office. The planning office simply started looking at what types of uses and where were they that you might want to include in that distance requirement. We didn't start drawing distances around it yet, because if you change that distance, then it impacts it. So I can't really comment on a map that was done by, unless you want to.
Yeah, we did play around quite a bit with, 1,000 feet, 500 feet. For the most part, based off of the most inclusive zoning option given, looks to be about 7 different sections of town. I'm not going to say that's parcels, I'm not going to say it's exact, but there are options based off of that, and then 1,000 feet from a church or school.
So there's some canvas there to work with.
Yeah, there is some.
Questions? Commissioner Pruish.
In terms of those 7 areas, though, one of them is not the central business district. You've excluded the central business district. It's 7 outside of the CBD.
The central business district was originally excluded because it wasn't part of the zoning language. But even with 1,000 square feet from a church or a school, inside the central business district, there's very
very little space that would be applicable.
Oh, okay.
Because you have a lot of churches, a couple schools. Yep.
What I don't know if this is defined in the statute or not, when they talk about schools, do they mean just K through 12 schools, or does it also include like OCC?
The statute talks about K through 12.
Just K
So,
through 12.
If you wanted to, you could include institutions like OCC, college, but the statute itself talks about K through 12.
Okay, thanks.
Any other questions?
Because now that Mr. Swing said it, I'm sort of curious. You said you were playing around with some of the, how you would differentiate between the different business types and it seems like the allowances, the setback allowances. What's your first thoughts about that?
Well, and again, we simply started with it at 1,000 feet because that was the max allowed by the state. Obviously, you can adjust that per type of use, per type of facility or establishment. And again, that's why the planning office didn't start mapping it. It is, if you only did 50 feet from a church in the CBD, then the space is much bigger. So it depends on what kind of direction you were going to get in that conversation. Whether you wanted to limit certain types of uses, if you want to preclude growers in the industrial district, you can write things like they need 5 acres and they need blank, blank, and blank from certain distances. You don't, well, you have to show that there's the ability to potentially put one in town. You don't have to make sure that one can come to town. Probably by example, an adult entertainment facility, we don't have any in town. We have at least 3 sites where you could put one if the property owner would allow that. So that's kind of depending on where you want to go with provisions and what your directive is, how restrictive you want to be. You'll see that we did not put anything in the draft about distances from residential zoned properties. Primarily because all of Woodward is next to residential zoned property. There's a lot of places that would come out of that, so we didn't put any distance requirements in from that to types of establishments or facilities. Those are some of the things we're looking at, and that's why we haven't mapped it yet. I don't have a good recommendation for you yet as to where we think those things should occur.
Questions on zoning? Commissioner Dubak.
I'm just curious, we've said distance to a church a couple times. Is that religious institution, or
yes.
How is that defined?
And that's interesting because that's one of the things I think we were looking at in terms of what do we count in that. And I think that's a conversation we'll have with Mr. Gillum. One of my thoughts was to identify those that we're aware of and include that map in the ordinance itself and say these are the established churches or religious institutions under our ordinance. And if there happens to be another one we missed for some reason, so be it. So there's a lot of little details that get through.
So I know you prepared an interactive map that we're not able to interact with this evening. Is that, are we able to move the metrics around and it change it? How does the interactive map work?
Well, that's our intent eventually,
Okay.
is to lay it over the districts and work with the IT on to be able to move that, shrink that based on. The factor I don't know right yet is if you have different standards, setbacks for a retail establishment versus consumption establishment, where they're going to go in relation would change. So you're going to potentially have a lot of factors that play into mapping that, versus if you have one distance requirement for all of them.
And would it then also account for if we were to consider a buffer zone, which is something we had talked about previously, which would be no one establishment can be within so close to another establishment?
That's correct.
Okay.
But until you put the first one in, you have no.
That's right.
Right.
So 7 areas could go down to 4 areas after if you go in somewhere, just based on the uniquenesses of geography.
Well, that'll be great to see.
Yeah.
When we see it.
Glad everything's so black and white.
Dealing with 8 dimensions here. It's sarcasm, by the way. Not the 8 dimensions.
I'm not sure where the commission wants to go forward. I would like to start this through the zoning process at the planning commission myself. I don't know at what point the city commission would be comfortable with that. I mean, if you don't want us to do anything, I'll sit on it. Otherwise, I would like to start that process. The commission can provide input along the way. I just believe this is going to take more than 1 or 2 meetings at the planning commission to come up with some recommendation to this body. And so I would very much like to start that process.
Yeah, I tend to agree. I mean, we heard of 3 major areas that need to be addressed: zoning, the licensing ordinance, what that's going to look like, and any sort of criminal ordinance amendments that need to be addressed as a result of what we do and how we do it. You know, where seems to be a very relevant question that you can try to tackle first, and then I'll say who, because you know you can start to work with the licensing ordinance to say, okay, you know, what does it mean in terms of criteria, additional criteria, what can and can't we do? But you got to start somewhere. It's not to say these things don't overlap or one issue that pops up in one area can't be solved in the other, but you got to start somewhere. I think I had Commissioner Douglas and Commissioner Prush.
Yeah, I like the zoning approach. I was pleased when I saw just the rough draft that the planning department gave us. I think we're going in a good direction. I like sort of their general suggestions of what types of establishments might go in what areas. Looking just at the existing zoning map, I thought that general business was a good choice. And initially I was in favor of CBD, Central Business District locations, but I take to heart particularly the fact the degree to which that drives up prices. And I think we're trying to build a central business district that is retail friendly. And we see in this town, I think there are landlords that are sitting on properties waiting for liquor licenses, where we might rather have a retail establishment, especially given what we're doing to bring workers into our downtown to shop at retail establishments. So I take to heart the experience that they've had and the knowledge that they've gained from other communities, knowing that Central Business District maybe isn't the right choice. So I like the approach to zoning. We can't make any decisions here tonight, but staff has a lot of autonomy to work on things that they think are important, and I wouldn't be surprised or disappointed if they started heading in that direction, said the planning commissioner.
Commissioner Bruce.
Speaking to that same point, if we're going to move in this direction, and I kind of have the sense that we're going to slowly move in this direction, the Plan Commission is going to have a crucial role in developing the language in the zoning ordinance, not only in terms of zoning categories and locations and setbacks but also the language if you're going to use a special land use permit, what kind of language in the special land use portion of the zoning ordinance is going to need to be developed. And we've had some education on this topic so far. We've been involved with the survey, we've had the study session. They're starting at square one. They have not had any of this stuff. So they're going to have to do an education process for the Plan Commission just to bring them up to where we are now. And then they can go forward talking about the specific zoning issues. So in terms of time, if we want to go in that direction, they really do need to get started because they're starting at square one.
There's a lot of head shaking.
Go ahead.
Mr. Gillum, anything else? Just a second, Mr. Gillum, I see him. Commissioner Dubak.
Hi. Yeah, I just wanted to remind folks, I think it's a reasonable course of action. we had put the February 1st deadline in place to ensure that the commission and staff are working in earnest and not just kind of kicking the can to not get this done. So I'm glad we're formulating a plan, but I do want to make sure that it's known that as long as we're working in earnest, you know, there should be openness if staff needs more time and the commission needs time to get it right, that we're committed to getting it right. And not just done by a particular deadline. The deadline is there so that the commission must act if it needs to be extended, so that people, you know, this commission or the next commission can't just sit on its hands and not address the issue. So that remains, but I guess it would be good to have clarity from staff as far as if an extension is absolutely necessary, what type of window would be needed for the commission to act. I'm hopeful we can get this done and done right with all the proper inputs by that deadline, but if it's not, it'd be good for the commission to know what kind of lead time is necessary for an extension.
It'd be helpful, I think, next time to actually have maybe, and I apologize if you sent it and I overlooked it, but maybe some sort of like timeline that really says, okay, in February, you know, working backwards, here are the things that we need to do, and here's typically what it takes, and here's a, you know, comfortable time frame, and here's a tight time frame, you know. I don't know, Tim, if you can.
Well, I
mean, even if it's just 5 bullet points that really kind of.
My intent, given what would be to put this in front of the planning commission, probably at their September meeting for discussion.
Okay.
Depending on their input and what they felt, they may set a public hearing for their October meeting.
Okay.
I think it's highly unlikely that they'll take any action at that October meeting. They'll listen and get input, direct staff to make revisions and bring it back at their November meeting. Assuming that they take some action in November, the first time you would see it would be sometime in December.
And then we could decide at that time if we need an extension, or if we know that the planning can't hear until October or November, and then we know our timeline slipped to a point where we have to reconsider.
To me, that's a optimistic timeline.
Right. Sure. Commissioner Douglas.
Nothing rules out special meetings by the planning commission.
That's true.
No, nothing does.
Except they're
they are arguing together at a special meeting.
I mean, you got 2 that may vote for it.
Well, and in terms of action by this body, it's the opt-out ordinance that would be the linchpin there. That's the one that's really the key. And that's an ordinance that would require 2 readings to amend. So if it's effective, the current expiration date or sunset date is February 1st. So that would mean we'd need to have, depending upon the dates of meetings in January, either first reading, second meeting in December, and second reading, first meeting in January, or possibly first reading, first meeting in January, and second reading, second meeting in January, if we had the 10-day window in there. But I'm just off the top of my head, I'm guessing it probably would have to be December, January, without any special meetings. We can nail down those dates for you.
Hopefully we have an understanding of when, you know, in December, you know, what the situation looks like with planning and, you know, where we're at, and we need to extend it by a few months, a few days, or, you know, hopefully we're not behind the 8 ball too much. It does look like, I mean, we are working in earnest. To Commissioner Doug's point, we don't want to work reckless.
So I totally think the most important thing is to get this right, and to be careful about it, and to draft some really good, strong ordinances that'll make this a smoother process for both the city and the staff and the applicants all together. But the concern that I have about being a city that's maybe behind in terms of opening this up is that all the cities are doing the same thing that we are. The applicants are looking at all the same cities with an eye to when this is going to be available. And the cities, like us, are going to do their best to pick the most strong competitive applicants. And if we are 4 months behind all the rest of our neighboring cities, they're going to take the strongest applicants in their first round, and we're going to be not getting those applicants. So I don't think it's a huge problem, because I think there's going to be hundreds of fantastic applicants out there. But I just wanted to throw that out there.
Commissioner DuBois.
I completely agree. I'm not in any way suggesting that anyone would be dragging their feet, but I just want to make sure we're reassuring the public that priority number one is getting it done right, but rest assured, this is going to get done.
Mr. Gill.
I don't know if the commission wanted to have any specific discussion about the Cobalt survey or not. It isn't an item on the agenda.
I know we had a review. Has anything changed since the last review that we had that was presented to the commission? The recent city commission meeting?
Not that I'm aware of, no.
Commissioner Macy?
So in my mind, something's changed because I didn't know, and I feel like this wasn't asked in the survey. If the question was, we asked specifically, would you like this one in there? What restrictions would you like on it? But it wasn't made clear to me, or I think in the survey, if you say that you want this one, do you understand that you're going to get everything? Or you have the potential to get everything in the, thank you, all these establishments in one go. So because that was news to me tonight, it made me think about the survey and whether or not we missed asking that question.
Yeah, I mean, certainly the question's not in there. Not that you can infer scientifically from any data, but you do see that at least for each individual one, there's an overwhelming response rate. So, you're right. Question of combination, does that diminish?
Yeah, I don't know.
You know, or does it, you know, and that would even be hard to get inside the mind of the 3,000 people or whatever that took it. I said processor, were they thinking just processors? Or were they thinking processor in conjunction with, you know, micro-business and retailers? Commissioner DuBois.
So it crossed my mind as well, but I do think that because each individual tests so close to how the electorate supported the proposal, that we can be confident that residents are okay with each of the types and are putting faith in us to construct an ordinance that doesn't clump them all together, doesn't have everything, you know, impacting, you know, one neighborhood, but that we'll do it thoughtfully, even though we do have to have the ability for each of them to be placed. It just makes the calculus a little more complicated, but I think the mandate remains the same, that we build this thoughtfully and so that not any one neighborhood is disproportionately impacted.
Commissioner Prush.
I think we just have to acknowledge the fact that this is an imperfect survey, and this is one of the reasons why. I mean, when we drafted the survey or when the staff drafted the survey and we kind of said, yeah, that sounds okay to us, we don't have any additional questions, we were coming from a certain level of knowledge at that time, and that certainly has changed since then. Over the last couple of months, we've learned a whole lot more, and if we were doing a survey now, we probably would write some questions a little bit differently. And that's going to continue on as this whole process goes forward. So I think we just kind of have to acknowledge the fact that this is a good general indication of how the community feels about a lot of this stuff, but it's flawed for a number of reasons, because our level of knowledge when we drafted it was less than what we have now, and so was the public's when they took it.
Yep.
So, you know, we're all learning in the same way as we go forward, and we just kind of have to take it as it is.
Then our duty, obviously, to look at all the small things, you know, that maybe not everyone considers because they don't have the experience or the knowledge set that we have as volunteers in the community to study these things in deep detail. Because maybe, you know, people have a certain opinion about growers, but maybe there are less complications with growers than we think, you know, and it makes certain prejudices, you know, not existent that might show up in a survey, or vice versa, you know. Maybe there are other technicalities that, you know, have nothing to do with, you know, marijuana itself, but the type of business and the other, you know, traffic or, you know, disturbance situations that could arise that we have an experience curve with, like businesses. So those are things we all have to, you know, rely on staff, rely on past experience, and, you know, convert into a formula that works for this town. So does that mean we're at the end of the work session if there's no other questions? Commissioner Douglas?
No, we're not. And I sounded the city attorney out in advance, so he kind of knew where I was coming from on this, but we haven't talked about building codes. How our building codes may and can and need to control the operations of these businesses, establishments. if we allow a growing facility, you could have a growing facility that grows tomatoes, but are there things about growing cannabis that require different types of building codes? And I think of odor in particular. With a testing facility, I don't know what goes on in a marijuana testing facility. Is it just a bunch of people with, test tubes and labs, just like you would get in any other medical analysis facility, or are there different things that we need to regulate differently? And so my question is, in addition to, for example, our zoning ordinance, are there elements of our building codes that we need to adjust as well? Mr. Gillum or Mr. Flake?
Well, from my perspective, I think you're going to have you're not going to adjust the building code because you're adopting the state construction code and the other codes. What you may do through your licensing ordinance or other things is require certain scrubbers or things that do smell to address smell, and they'd have to put them in, and then they would be evaluated for electrical and ventilation and things under the building code. I don't think you're going to be able to change the state building codes.
Right.
So where you would place those other things you want to address, I think, is either in the licensing ordinance or, again, if it's related to the use, in the zoning ordinance. And then the building department would simply, they'd have to submit plans that addressed all of those in order to get the license and in order to pass planning and get signed off, and then they'd be reviewed under the building code.
Okay.
And there are different construction types, so depending on what they fall under, they build to that.
Okay.
Commissioner Macy.
Do you have any idea if the state is planning to modify the building codes in any way to adapt for this or not?
Not that I'm aware of.
Yeah, I haven't seen any reference to any changes in the construction code either. So, but I mean, the emergency rules are clear that, at least in terms of the establishments, that the state construction code does apply, the fire code does apply. There are other regulatory codes that apply in terms of edibles and other products, that the regulations that apply to food products apply to those. Someone who wants to come in and open up an establishment is going to have to get a building permit. They're going to have to get certificates of occupancy. They're going to have to do the same thing that basically any other general user would have to do. Both of the acts, both the MMFLA and the MRTMA, they do allow us to specifically regulate things. But at the same time, both of them say there are some things that we cannot regulate, including anything that puts it directly at odds with either of the statutes. But there is some fuzzy language in here, again, for in particular language in the MRTMA that talks about our ability to adopt other ordinances that are not, quote, unreasonably impracticable. What does that mean? The explanation that we get from the state is that it means ordinances that would require an otherwise reasonable person, not from wanting to put the time, the money, and the effort into going forward. But as to exactly how that's going to be interpreted, I mean, that's got work for lawyers written all over it. So I don't know. There are some things that we can do specifically. There are some things that we may be able to do. There are some things that we probably won't be able to do. Odor, as I indicated to you, I think odor is a potential problem. So just because I think generally the idea of trying to restrict or enforce odor in general is a problem because it can be such a subjective standard. So.
Commissioner DuBois.
Yeah, I think kind of on that same point, this is not an issue I'm expert in. One of the folks in attendance can tell me if I'm way off base on this, but I would assume like a grow facility would be a huge drain on the energy grid. I would assume it would consume a lot of energy. Could we, as part of our ordinance, require certain environmental standards for facilities based on the type? So if it's a huge drain on the energy grid, on water, we require green roofs, solar, things like that. Would that not be in the realm of possibility?
Well, we've had some discussion about how to address energy supply and whether or not you could give bonuses for addressing it in some fashion. I don't have anything in particular I can tell you at this point, but we're looking at it.
My suggestion to the commission would be, as we go further down the road here, is that we actually reach out to Edison and see if we can have someone from Edison come and give us their perspective on it. I did have a chance to talk to Mr. Gomez last week, recognizing that he's not an employee of Detroit Edison any longer, but he was at one time, and what he indicated to me was, at that time, Edison saw this issue coming, and so they're trying to figure out ways that they can deal proactively with the drain on the energy grid. Obviously, I think from the city's standpoint, we don't want to be approving businesses that are going to cause such a drain on the energy grid that it's going to negatively impact the typical service that's given to all of our other customers and residents. So yeah, we may want to get some direction from DTE as to what they're doing and what we might be able to do to help them, and vice versa.
Questions, Commissioner Douglas?
I have one last question. The draft zoning ordinance that staff prepared talked about medical facilities as well as recreational establishments. And I'm wondering, why would we need medical facilities if we allow all forms of recreational adult use, particularly establishments, particularly where people can acquire the product, growing, transporting is not so much a big deal. But if people want, marijuana for medical consumption and it's available for recreational use, is there a difference in product, or can't they just go buy what they need?
Or grow their own.
Ah.
How many plants can an individual grow? 12? 4?
Yeah, let me do some more work on that and maybe give you an idea. As I indicated before, there are some distinctions, but between the two acts. But let me take a closer look at those, do some research, and maybe spell those out for you, and then we can figure out if they're really distinctions without a difference or not.
Yeah, thanks.
Mr. Gillum, you had mentioned, there's some do's, some don'ts, and some fuzzy areas, right? Are you, or is it your intention, or how would you like to proceed with, putting together a list of some of those as it relates to, let's say, licensing, maybe even zoning? I'm thinking that would be helpful for this body, to say, I'm sure we could even email you all the, some of us have privilege of not being a lawyer, so our ideas can be anything. Say, yeah, I'm not a lawyer, I didn't know. Maybe for some that are, it's a little bit, tensionous, but, if we could, if we have some ideas or thoughts, or if you have something prescribed already or something on paper, I think that would be helpful to kind of get us thinking a little bit, like, okay, here, if we're going to be prepared for another discussion, what are some of the things, and certainly I can help you with my ideas, send you a quick email with 10 things I think, whether I support them or not, that I think the public would want to know. Do we have the right to do this or that? That might be helpful for us, I think, moving forward. So before I lost that thought, I want to make sure I can be.
No, and that would help me too. If you can identify for me issues that are, or potential issues, and I can take a look at them and tell you whether or not those are things that I think we can do or things that we can't. Some of the specifics, the stuff that's very clear, I have given to you in the information, but granted, there was a ton of stuff that I gave to you too, so.
Okay, I wasn't sure that.
I was just going to say, I think that one place to start would be that list that Commissioner Douglas was talking about that was in the survey of things that people would like to have regulated. So maybe looking at that and saying that is this something we can regulate? If so, in what form would we be able to regulate it?
Right.
Where would it show up?
That's a really good point. That's a good place to start.
And actually, when we put when the survey was put together, one of the things that Judy and I had talked about some of the things that were originally in here are things that we just clearly could not do. So, but I agree that this would be a great place to start.
Anything to add, Chief O'Donoghue?
Yes, sir.
Okay, good. Wow. Awkward silence. I feel like motivating more conversation.
Or a
But
motion
I
to
feel like
close.
there's.
We gotta go to public comment, right?
Oh, yeah, that's right.
Yeah.
I thought we did that.
Obviously, we can't take any action tonight. Is there anything, maybe kind of just doing one last gut check here, that anyone wants to discuss tonight? Or anything that we want as a deliverable for the next work session?
Can we stay, keep our minds open until after public
Yeah.
comment and see if that stimulates anything that we do
Yeah.
want to
Sure.
add to the?
Yeah, we can, there's no reason why we have to adjourn right after public comment, that's for sure. Mr. DeBuck?
I just wonder if we can get an inventory of staff next steps that we've identified here. I just want to make sure we're all clear on where we're going.
We're adding to the inventory right now.
All right.
Okay, Mr. Gillum, those wonderful notes you have there on that blank piece of paper. Can we just get, Mr. DeBuck asked if we could just get an inventory of kind of the follow-up items, next steps, and where we see the process heading?
Well, I think Tim has talked about what he would intend to do from a zoning standpoint. Then I've made a list of issues or questions that came up during our discussion tonight that I think I owe you some research and or some explanations on. So from a licensing standpoint, I think my next step, I think I mentioned to you before that I've had some discussions with the firm over at Dickinson Wright, which, like a lot of other firms, has its cannabis group to represent the industry side, but they also have a marijuana group that's representing the municipal side. So I probably reach out to LeVasseur and talk to her and get some ideas as to what they might be able to do to give us some help, what they might want to charge us to do that. And I can report that back to you and then possibly bring them on board to help me out, especially as long as I continue to be short-staffed in my office. So, and then maybe we need to think about when we want to pick up the discussion again. This is the end of July now.
Yeah, we have a long bridge between now and our next meeting in August. Well, maybe, I mean, we do have on Monday, a week from now, a special meeting, but, I mean, that's too soon, but maybe, at least moving forward, definitely, I would say, on our next commission meeting, we need some sort of update or discussion point where we stand, because listening to Mr. Twing, I mean, the planning's gonna go in September, and I think, you know, we can wait, try to get, you know, in September an update, but maybe we have something on our next agenda that just says, okay, here's an update of where we stand, you know, based on feedback you get from us. Where do you think we should go? Mr. Douglas?
I mean, should we be approving some principles? I mean, at some point, we need to vote, you know, to give official direction to staff.
Right.
I mean, it seems like we need maybe a set of policy directives, a list of, I'm gonna say, you know, 5-ish, actual formal policy statements that will guide what the staff is going to do.
If I could, I mean, in terms of the information that I gave you tonight, after each sub-item, if you will, there were 2 or 3 or 4 questions that I laid out for you. So maybe in terms of what I give back to you in the next week or so, I include a list of those questions. So
Yep.
maybe that'll help you focus your analysis in terms of what you need to be thinking about. Because I think those are questions that not only do I need to know, I think the rest of the staff needs to know too, going forward.
Yeah, if we're gonna play with the zoning map, I think some of those fundamental questions need to be answered, so you know what levers to pull on it, and see what it looks like.
Can we do that in 3 weeks? Do we need to do that in 3 weeks?
Well, and it's always a challenge because how do you do it from, I mean, there's two ways you can go about it. I mean, staff can try to guess and predict based on the conversation and put together a few modes. We can, offer up individually some feedback to staff privately, so we, don't violate any Michigan Open Meetings Act, but give them a little bit more information and detail so they can bring something to us in a few weeks as a proposal. I leave it up to staff to kind of tell us how you want to interact with us. Knowing that, one, our priority at this point coming out of the work session is we've learned some stuff, but I don't think there's any disagreement here. We want to work earnestly to get this issue resolved. I think staff does too, so we're on the same page there. But with that major consideration, how do you think to best proceed? I don't know if that's putting you on the spot now, but.
Well, I know one of the things that you asked for at your last meeting, and we would have for you tonight, but for the fact that we have no power, is that information about setbacks and buffer zones and things like that. I mean, the interactive map, I think, is really, it's kind of eye-opening.
Yeah.
So, I don't know, I'm just thinking off the top of my head, maybe we could bring that back to you at your next meeting. I mean, that basically is, it's close to done now.
Yeah.
So we could bring that back in 3 weeks, and again, I'll be giving you other information in the meantime. Maybe that'll spark other discussion or conversation. We just take it one step at a time.
Zoning seems to be the more, I don't say bottleneck, but, the other elements as far as licensing. Not that we have more time, but, if we tackle the zoning one first and really start to understand some of those dynamics and what the geography looks like, and there's legitimately mathematical constraints, then that can help us decide how we might handle some of those issues or not handle some of those issues within licensing or, criminal code. So you think, what I'm hearing is that your recommendation is that we move forward, maybe the next meeting with the zoning map, couldn't have it here tonight, kind of see how that works, spend a little extra discussion time on zoning. In the meantime, do you appreciate or wish, I heard you say, Mr. Gillum, like if we have any thoughts or questions, we still continue to push those to you.
Absolutely.
To help shape your strategy on how to present something to us, because, I don't know how you would, either you present 7 individual plans or you try to take the input and get us something that looks workable and doable, and then we can finesse it at the table. So I think logical next step was to start getting you more information. Maybe we learn a little bit more from public comment. And then the next city commission meeting, schedule some time to view the maps.
And see where that takes us.
Okay. Yeah. Everybody on board with that? Not that we're voting, but does anyone strongly reject that concept? Okay, I don't see any harsh criticism, so your plan is perfect, Mr. Gillum, at this point.
We shall make it so.
All right, well, I think what we're going to do now is we're going to open it up to public comment. And we may continue discussing after things we learn in public comment, or we may take those up at another time. Just like we had at the city commission meeting, we rely on the input of our fellow citizens to make decisions. We ask that you keep comments to 3 minutes or less so we can hear from anyone who wishes to speak tonight. Again, we'll have to wave our hand here. If you could state your name and address for the record before you begin speaking, we'd appreciate that. So with that, I'm going to open it up to public comment. Who's first?
Oh,
Come on.
Kurt Von Eberstein, 3115 Clausen Avenue. I really wasn't planning on speaking tonight, but and I haven't studied the issue that closely. So I took the survey. I did fill it out, but that was months back. My first question would be security. You can certainly regulate that, I think, especially in the medical facilities. Medical marijuana and, again, whether or not you can combine medical and recreational, I think it's almost kind of a must if you want to regulate it even more so, a little more tightly. But security would be like, do they take inventory? Are they held to pharmaceutical standards? God, is CVS going to get it into it? Walgreens, I don't know. This stuff could be developed for seizures, brain tumors, it could be an accepted medical practice, so. But security, that's my big thing, is that inside thievery, outside thievery, maybe they could all pool their profits, you know, you get a cut and you put one big friggin' wind turbine up in the downtown area and you take care of the energy sustainability, or a couple of them. So that was really it. It's my 2 cents. Security.
Thank you. Yep. Anybody else wish to speak tonight? Yes, sir.
Council Commissioners, my name is John Travis Harrison, and I represent Emerald Growth Partners and Pleasant Trees Retail. I spent the last 15 years at Ralph Lauren in New York and Los Angeles, and the last 4 years here in the state of Michigan. My wife and I live in Detroit City. I've worked for Shinola, headed up their retail establishment for the last 4 years, expanded 27 businesses for them globally. 6 of which hopefully many of you have experienced here in the state of Michigan. I joined the organization roughly 9 months ago and really have worked on the front lines with many of you all in other municipalities across the state to figure out the questions that you all are faced with. And I just wanted to express the gratitude and thanks for what you all are going through. Obviously, we have the hope and expectation that we can deliver to the consumers of cannabis, both medicinally but also recreationally, an elevated, upstanding experience, much like that of Shinola or a Ralph Lauren establishment. And as the gentleman prior to me had mentioned, there's a lot of work that we are doing within the communities across the state of Michigan here, where we hope to give back to those communities. Not quite wind tunnels per se, or wind turbines, but it's a great idea. Some of those cities, we've given back 1% of all net revenues. We've donated additionally to those communities different figures and sums to help establish ourselves within those communities so that we might be able to give back, whether it be a senior population and/or some of those other consumer types, whether they're trading alcohol for cannabis. So there's a lot of great things that are coming from this that we've seen. Obviously, there's a tremendous amount of perception within the industry. Certainly, being an outsider from Michigan, only having lived here for 4 years, and now working in the cannabis industry, I've seen the way that cannabis has been presented within the state, and it hasn't been in the most positive of light. But I can tell you that, and I believe, Melanie, you said there are a lot of great candidates lining up out there. There are. We work with a lot of them transparently within the industry, and I look forward to being one of those organizations here in the city of Royal Oak.
Thank you. Anybody else that wishes to speak tonight? Mark.
Council, how you doing, everybody? Just want to say, first and foremost, this meeting is definitely appreciated. Somebody who's been embedded into the city for a number of years, it's great to see the progressive nature that the city's taken on over the past 6 to 12 months, not just cannabis. I think cannabis is just one of the variables that we're facing today. But one thing that I want to push strongly that I've seen across multiple markets in this space is the willingness for local operation, and how important that is to our group and how important that is to a lot of groups out there. And the reason that I state that is because we've been involved in a lot of competitive processes across the state already, and the perception that we've seen is outside of Michigan, cannabis companies are perceived in Michigan as the guys who should be doing it, when I think how it should be seen is the people in Michigan are now given the opportunity to catch up to those guys across the country. And Royal Oak has a progressive community, and I know one that cares about its citizens and the ones around them. I think even to Commissioner Councilwoman Macy's point, it's so important that you guys do kind of maybe keep the burners up a little bit on this process so that you guys do get those best operators, but even more importantly, those best local operators and practitioners. Quality Roots is more committed to educating the community or communities that we're going to embody more than we are into selling cannabis. We understand that we need to be recognized as educators the educational platform with this variable in place. And as all of you guys know, me as an experienced operator and the type of experience I deliver, again, cannabis is just a variable. Experience and education first. Thank you.
Thanks, Eric.
I'm sorry.
Eric, before you go, can we get your name and address for the record?
Eric Clark, 123 South Main Street and 119 South Main Street.
Thank you, Eric. All right, who's next? Who should speak tonight? Anybody else? Going once? Going twice? All right, we're bringing the meeting back to this side of the table. Any further discussion on this end? I think we have a plan moving forward. We're kind of aligned on what the next steps are. We got a lot of information here tonight. So much we drop our cell phones. Commissioner LeVasseur?
With regard to some of the items that might be useful, the Cobalt survey results were a little bit on the light side, and I'm just wondering if there's a greater detail that they may be able to provide us as to any specific concerns or thoughts. It was all generalized. I believe there was an aspect where folks could give additional perspective, additional reasons why they believe a certain way we should proceed. And just so that commentary, I think, could be helpful for us.
Anything else? Mr. Macy?
So I agree with that, but, so, what are we doing now? Are we emailing somebody our thoughts?
Yes.
Okay.
Or questions.
Thoughts or questions?
So I think, I mean, you don't have to email. I think that the general, you know, we have a few weeks till the next meeting. Next meeting, we're going to focus on zoning topics, the zoning map. Between now and then, as questions, ideas, things pop up, I think that our staff would appreciate with a little heads up where your mind might be at, what questions you might ask, what ideas you might have, either for zoning or for licensing or for, you know, the criminal ordinance aspect of it. And then that way we can, you know, if there's a strong no, like, okay, why, you know, maybe we bring it up, that at least it's prepared, the answer's there, and we're a little bit more productive with the time we have together, like we do typically. Yes,
And
Commissioner
Mr.
Douglas.
Gillum's going to summarize, pull out his questions that were
Yes. Yeah, so-
salted through his document here.
So we're not
And
just.
share those with us.
Right, we're not just asking questions, we're hopefully giving some answers too.
Yeah.
Kind of, so they can kind of see what the, you know, I don't want to say consensus, but sort of survey the commission to kind of see where we're at with answering some basic questions. You know, everybody is completely unique and different. That's going to be a fun discussion, but if most of us seem to be relatively on the same page, then, you know, that really helps staff to construct a, I like to say, a piece of clay that we're going to mold and shape into something that, you know, works well for everyone.
Yeah, in terms of those questions, I'll forward those to you, and I'm not looking for responses to those. I think those are really fodder for your next discussion or discussion at a later date. Those are issues that you're going to have to work your way through as a group. So.
Any other questions? Any other discussion?
I move we adjourn.
Motion by Commissioner Douglas, is there a second? Second by Commissioner Gibbs. Discussion on the motion to adjourn. All right, with that, I'll call for the vote. Those in favor say aye.
Aye.
Those opposed, motion passes. We're adjourned. Thank you everyone for coming out tonight, really appreciate it.
Discussion.